Welcome back to Radio Entrepreneurs. I'm Jonathan Freedman, and our next guest needs no introduction, Mark Furman, another segment of Entrepreneurship and the Law. How are you, Mark?
I'm great, Jonathan. It's great to see you.
Great to see you. I should say Mark Furman, director and shareholder of Tarlow, Hart Rodgers. Always a pleasure to have you. So you wanted to talk about a recent decision that the court has handed down. Tell
Yes,
us, tell us your thoughts.
well, the United States Supreme Court ends its term typically at the end of June, and at
With a
the
flurry, with a flurry.
with a flurry of decisions, and uh, some of them are quite significant. And there's one I wanted to talk about. There's been a rule for 40 years that when a law written by Congress is ambiguous, that the courts are supposed to defer to any reasonable interpretation by the government agencies. So the way our system is set up is Congress passes the laws, and then in a lot of times they're quite general, and there are these government agencies who interpret the laws, who write rules and regulations, and that sort of put the meat on the bone, so to speak, as to what the law means. And then when the agencies come out with a rule, it's frequently challenged by an unhappy party. So they go to federal court, and they challenge the rule. And as I indicated, the rule had been for about 40 years. This came out of a case called Chevron, a rule of deference to the administrative agency's interpretation. Well, Chevron was overruled, and there is no longer that deference accorded to federal agency interpretations of ambiguous laws. The theory behind Chevron deference was Congress can't have the subject matter expertise that's necessary to deal with fairly complex issues like air quality, environmental protection, water quality, and a host of other things, and that agencies are staffed with people who have greater expertise in those areas. And that was a part of the reason for deference. But a new day has dawned, and
So tell us a little bit about what the implication of that was. So the implication of that was whenever there was a challenge of sorts, then it would defer to the agency because they have the subject matter experts, essentially.
yes, so
Okay.
you were in the event that the law was ambiguous, any reasonable interpretation of the by the agency would be upheld.
Would stand. Okay.
And understand that regulations have the force of law, just like a statute passed by Congress. The difference is regulations aren't passed by Congress. They're not passed by officials who are elected, who are accountable directly to the voters. Um,
And
so
those can be far-ranging in terms of implications for industry and business, et cetera.
yeah, and just think of any area: labor, employment, as I mentioned, environmental protection, securities law, interstate commerce, a whole variety of um, rules relating to education, um, uh, discrimination, uh, things that aren't explicitly spelled out by Congress, where anything that's considered to be ambiguous. So now Chevron deference has been eliminated, and there's going to be a whole lot of challenges. And instead of the the playing field being a little bit tipped in favor of the agency's interpretation, that's no longer going to be the case. I think it's also going to have significant implications for lawmaking in Congress because, Congress is going to have to be more specific when they pass laws, and they're going to need greater subject matter expertise. So I'd say critics of this decision would suggest that we're going to have more specific laws drafted by lobbyists for particular industries to try to deal with this. And another thing that's quite
so Mark, just the thing that comes to mind when you're talking about this. I mean, it sounds like it's an effort at greater deregulation in essence, or at least trying to take some teeth out of regulation and perhaps swinging in favor of less regulation by agencies. Is that a fair?
I think that's a fair way to look at it as well. It's also very interesting because the Administrative Procedures Act, which is the federal law that under which these rules and regulations are promulgated by agencies, also exists in various states, and the language is very, very similar. So, for example, Massachusetts, where I'm located, has a State Administrative Procedures Act. And there has been a rule of deference to agencies under the Massachusetts Administrative Procedures Act. So will states interpret their statutes that deal with regulations by administrative agencies and follow the United States Supreme Court, or will they continue to defer to a greater extent to decisions by state administrative agencies? Because just as we have federal lawmakers and federal agencies who make regulations, we have state lawmakers and we have state agencies, and they make enact, promulgate regulations that govern on a state law. And for business owners, they can have a problem with federal law and they can have a problem with state law. And so we may end up with potentially different approaches under administrative procedures, challenges to regulations by administrative agencies on a state level versus on a federal level. So
sounds promising for your field, for the law, because it sounds like there will be a whole bunch of new challenges that are raised in many cases.
There will. I mean, there's in a number of areas, there's been just dramatic changes by the United States Supreme Court as presently constituted, as former President Trump appointed 3 judges to the court, and certainly that has moved the court in a more conservative direction without any question. So, we'll have to see how this plays out. Already, just in the last 10 days or so, a number of cases have been remanded for consideration of decisions by lower federal courts in light of this decision that came down abolishing Chevron Deference. So something to keep an eye on, and we'll see what happens. Of course, business owners are subjected to a lot of regulations on a state and federal level. We live in a highly regulated society, and it's so I do think that this decision will impact many businesses in their during the life of the business.
Well, I think the interesting thing about it is, we all hear about the high profile cases that come before the court, and that's what makes all the news. Obviously with the political charged climate, there's a lot of things that, fall far to the right or far to the left. This seems to be one that maybe a little more, in the center, but nonetheless, big implications for businesses and for entrepreneurs. So it seems to me the challenge there is that since they don't get a lot of airplay, how are businesses to even be aware of, changes in the landscape, et cetera. So I think it brings with it a host of challenges, as any regulation shift does or landscape shift does.
Yeah, I think there's business owners, I certainly believe, need to have a strong team of advisors. They need their strong accountant, they need legal advice, they need insurance advice. Dare I say, they need business consultants like yourself, Jonathan, and you need to get that input because nobody can be up on everything.
Absolutely. And as you talk about it in a more complicated world with much more information coming at you on a daily basis, it's hard to parse what's important to you and what's not.
It's much more important to avoid getting in the crosshairs of a government agency by avoiding conduct that can get you in trouble. And then instead of challenging the decisions of the government agency, and there's a high cost to that, even if you win. So best to avoid those kind of problems if possible.
I can imagine. Mark Furman, Director and Shareholder of Tarlow, Breed, Hart Rodgers. Always great to have you on and bring us insights into what's going on in the world and the implications for business. If people want to reach out to you, find out more about how this might impact them, their industry, their particular circumstances, what's the best way for them to reach to you?
Best way to reach me is by email, mfurman, Furman, at TBHR-law.com.
This has been another segment of Entrepreneurship and the Law with Mark Furman. A pleasure having you on as always. And we'll be right back with another segment on Radio Entrepreneurs.